it's just kind of wild that they're going to look into basically which parts of the same faith a church is emphasizing and decide whether they're what politically correct, whether they're okay in our modern society. It's so wild to see a court dive this deeply into, like you said, the contents of a prayer and the doctrinal emphases of a church, and deciding whether it's okay for a mom to take her own daughter to church. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. Interesting and kind of complex series of cases today. We're going to start with a Maine Supreme Court case that will decide whether a mother can bring her daughter to church. Yes, really. And then we'll talk about a Christian nonprofit in Oregon that is appealing a loss of grant money due to its hiring practices based on its religion. And we will finish up by touching on a rather complicated regulatory legal battle involving an HHS medical privacy rule and the lawsuit that ensued over that. So let's start today in Maine. Just for a little backstory, there's a woman at issue in this case. Her name is Emily Bickford. She's a member of the Calvary Chapel Church in Portland, Maine. Now, this is in court because it's a family court custody dispute over a divorced couple and their daughter. So she has partial custody of her 11-year-old daughter and would often bring her to the Calvary Chapel Church's services when she had her daughter with her. So a Maine trial court somewhat recently, ruled that the woman was exposing her daughter to cultish activity and major psychological harm by taking the daughter to church. As such, even while maintaining partial custody and being a fit parent in all other respects, the mother was barred from bringing her daughter to any more Calvary Chapel services or events. And further, the woman was required to receive permission from the father before bringing her to any religious services. So this went up, I believe, from the Maine trial court to the intermediate appellate court and is now going in front of the Maine Supreme Court. I think there'll be oral arguments in November. And the woman, Emily Bickford, is arguing that the trial court's decision violates her rights guaranteed by the First Amendment and the 14th Amendment due process. So I want to focus on a couple of things in this case. For one, I think by ruling that protected religious beliefs and practices, like going to a church, are psychologically harmful to a minor. I mean, there's so much going wrong constitutionally here. It seems pretty clear that the court's violating the court's guarantee of free exercise. There are some clear church autonomy issues here when you look at the trial court record and how much the court is delving into the religious beliefs and the prayer practices of the pastor and the church. And Joseph will cover a little more on the church autonomy part of it. But the trial court effectively required Miss Bickford to prove the truth of her religious claims. And so after they examine the content of the church's professed beliefs and prayers in quite some detail, and the court holds that a parent who brings her child to a church that teaches such views is unworthy of the court's protection and unfit to make decisions regarding that child's religious upbringing. Now, I want to touch on this because teaches such views. Obviously, I'm taking a quote out of context. What are such views? There's a lot going on in the court's analysis, which is quite shocking. But if you get into it, they're not they call this cultish activity, but what they're actually talking about is just conservative Protestantism. And I would say this is, from what I read of the court record, this is not really outside the mainstream of like a more, I mean, I'm not as up to date on like on Protestant denominations and divisions, but I think it's like a fundamentalist or like a strict Bible church. And so a lot of the stuff that was coming up in the trial court record was, the pastor's emphasis on sin and death, on the coming of the reign of Antichrist, on eternal damnation for those who are not converted. And I mean, right, this isn't a death cult, right? This is all in the scriptures. Like, he's preaching from Revelation, he's preaching from the Bible. And like, even just a little bit I've read, I don't have the same views on the reign of Antichrist and how the end times will look, but that's not really the point. And it's certainly not the court's business to look into the particular eschatology of a Christian church and decide that it's just too far out there and it makes this woman unfit to decide her child's religious upbringing. It's really a wild case. So I think reining in here, I'll try to make a couple quick points. One problem is there's a murky distinction here between what would you, the court says this is cultic, right? Is this church a cult? But what does that mean? What's the distinction between a cult and a religion for purposes of like a family court deciding when a parent is exercising their constitutional right to raise their child in religion and when they're taking them to a cult? I don't know. Traditionally, cult, like from the Latin word cultus, just means like a system of religion or worship. It's where we get words like culture. In more modern times, yeah, it's taken on like the negative connotation of like a strange, false, closed belief system. We think of like, right, Jim Jones or like the Waco uh, disaster. And but so we've now associated cult as having this negative connotation of like it's outside the normal religious world. It's a closed belief system with a charismatic, coercive leader bringing people into dangerous things, blah, blah, blah. But to me, this is not like a precise, there's religion and then there's cult. And so the court can clearly decide, well, that's not in the realm of First Amendment religious protection because it's not a religion, it's a cult. It seems murky to me what they're doing here. And I think it opens the door to saying like, moderate, inoffensive to secular culture religions, those are religions. Conservative, bad views on sexuality or marriage, or that's a cult, right? So I don't know what's going on outside of some obvious cases of like something violent or abusive going on. It's hard to see how the court is expected to draw lines between what's a cult versus a First Amendment protected religion, or how it has the authority to do that in this case. So getting to my, I guess, final point, the court acts here as if it's making some reasonable objective inquiry, right, into whether the minor child is being brought to attend a dangerous, harmful cult or practice, right? But and this is obviously untrue. As I said a couple minutes ago, this Calvary Chapel Church, I looked it up, looks like a typical, extremely conservative, sola scriptura, we read the Bible literally, Protestant Bible church. Yeah, they preach a lot about sin and hell and death, but the Bible is full of these exact teachings. So the court may not like it and may want to try to psychologize what this kind of like more brimstone, hellfire kind of preaching of Christianity can do to an 11-year-old, but it is a preaching of Christianity, right? This is religious preaching, this is religious teaching. And yeah, the church seems to have a particularly charismatic, bold, forceful pastor. But again, this is typical. This is just a Christian church. So the reality is this is not like a weird, fringe, dangerous cult organization. It's a conservative church that falls squarely within the American Protestant tradition and therefore the class of protected religions under the Constitution, and attempting to treat Calvary Chapel as if it's like in some distinct category separate from a religion or separate from a church, that to me is just an attempt to treat conservative Christians who accept hard biblical teachings on, death, heaven and hell, sexuality, and so on, as outside the scope of reasonable religion in the modern age. That violates the free exercise clause, period. I also just want to end with this, and then I'll turn it over to you, Joseph. I think this also gets at a line of reasoning that's now going to be more prevalent in the wake of the Wisconsin Catholic Charities case, right? This is the case of a government body impermissibly making doctrinal decisions about which types of religion are worthy of government favor and which are not, right? I mean, the trial court, I quoted it earlier. What did they say? The church that teaches such views is unworthy of the court's protection. But there are clearly other kinds of religions that this court would say are worthy of their protection under the First Amendment. So then we get into this area that Justice Sotomayor wrote in the unanimous Catholic Charities case, that if a government body is saying we protect this kind of religion but not that kind of religion by law, that's an establishment clause problem. You're favoring some kinds of religion and disfavoring others, and we pretty clearly don't allow that in our constitutional system. So not right on point with Catholic Charities, but I do think it raises the same kinds of issues like this that we should be looking out for, because the court is clearly saying, yeah, of course we protect religious exercise if it's the right kind. And not only do we not want a society that goes there, but we apparently can't have one according to the First Amendment and certainly current Supreme Court precedent. So Joseph, I'll turn it over to you. I'm curious to hear your thoughts, especially on the church autonomy side of this case.
Yeah, thanks for covering kind of the the main upshot in this case and really what's going on. I do want to add some color to some of the church autonomy considerations here. Now, this is a child custody case, right? So it's not one you typically think would necessitate invoking the church autonomy doctrine, right? You think of the Huntsman decision that we wrote a blog post about, where one of the plaintiffs in the party basically is a church, right? In there, the court ultimately decided this was a case related to the Mormon church's tithing practices. And there they ultimately ruled that in order to make a decision, or there's a concurrence, this wasn't the ruling, but in the concurrence, which brought up some great points, they said that we shouldn't have actually really ruled here because we have to define what tithing means and make a normative decision on an internal church ruling. So while this isn't kind of a typical church autonomy case you would think of, because no plaintiff is a church, much of this decision really examines the mainstream church's beliefs in order to determine their validity or invalidity. In the district or the trial court's decision, there were about 3 pages where it was just directly quoting from the pastor's prayer. I don't know how they got that prayer or not, but either way, there's direct quotations from this the pastor's prayer. And then he asked the congregation to pray for the mom and the daughter. He said, we've known, the mom's name is Emily. We've known Emily for so long, and we've known her daughter, and we just ask you to pray for them. And then he also asked, please pray for the dad. He wasn't even saying this man is horrible. But then the trial court walks through this prayer section by section and makes normative statements about how valid this prayer is. And it had a few problems with it, right? For one, it said that an issue with this church's action was that it suggested that there is a right and a wrong side to this dispute. And it said that the prayer was, quote, sad. I was rather surprised to see that a court would rule officially that a prayer is sad. It's definitely outside of the realm of what our judiciary exists to do. And there's a great quotation from the appeal to the Maine Supreme Court, where it says the lower court's decision went step by step through much of the chapel's mainstream religious views in order to suggest that the parent is unworthy of the court's protection, like you mentioned. So just by suggesting that the church's beliefs are, quote, scary, quote, homophobic, and claim objective truths, the district court ruled that these normative statements cause serious psychological harm. So it was just very surprising to see a district court diving into the actual content of a service and making statements about whether or not it's valid, and in effect requiring a plaintiff to prove that her religious beliefs were accurate in order to rule in her favor. And that just is so far beyond the pale of what the court exists to do, and is certainly activity that the First Amendment would preclude when properly interpreted and applied.
Yeah, that's such an interesting point. I think you're right. The church autonomy, you have to use it kind of analogously because it's not actually a church that's
Right.
being, or a religious organization that's being looked into. But it's the same analogous problem of the secular courts going well beyond their jurisdiction and talking about doctrinal issues. So I think there's the Establishment Clause problem that Justice Sotomayor had mentioned in Catholic Charity. But also, I think the last thing you I don't know how much you said about this, but in your notes for preparing for this, the court suggested that the church's beliefs are based on scary stories or homophobic. It's like, it's just wild to me to read these kind of quotes from the trial court, because it's like, okay, so if the church is talking about Revelation, right, and like the serpent and these are scary stories. If you're talking about like one of Jesus's nicer parables, I guess that would probably be fine, right? If you're talking about like condemnation of same-sex acts, that's homophobic. But if you quote Jesus and say, little children love one another, I'm sure the court would be fine with that. So it's just kind of wild that they're going to look into basically which parts of the same faith a church is emphasizing and decide whether they're what politically correct, whether they're okay in our modern society. It's so wild to see a court dive this deeply into, like you said, the contents of a prayer and the doctrinal emphases of a church, and deciding whether it's okay for a mom to take her own daughter to church. I won't go on. It was a pretty shocking case to read, I have to say.
Yeah, especially when in all other aspects, the mom was found fit as a parent. There were no problems. She has never had really an issue in the custody stuff. It's just, oh, is this church she's bringing her to is quote unquote scary. It's just so wild to see a court um, making this normative statement about a faith.
Yeah.
So with that, we'll move into our second update of the week, where there's a Christian ministry for at-risk youth is currently appealing to the Ninth Circuit in order to regain a state grant. So 71.5 Ministries is a group that provides free mentoring and vocational training for kids that are in challenging circumstances. And for years, they've received grants from the Oregon Department of Education through this state program. And the state program is for investment in like youth organizations and people that try to help the young people in the state. Up until a couple of years ago, that's when this kind of started becoming an issue. In 2023, the Department of Education added a new requirement basically for any organization that's receiving funds through that program. They have to certify that they don't discriminate based on a number of characteristics, including religion and sexual orientation, when they're deciding whether or not to hire somebody or otherwise. So the nonprofit 71.5 is a Christian organization. They serve people of all faiths. Like I said, it's vocational and mentoring. So it doesn't matter what background the kid comes from. If they're a child that needs help, great, we'll help you out. But they do only hire people that share their religious values, being a Christian nonprofit. And because of that, and because of this new policy, they ended up losing over $400,000 in state grants. And a really key note to include in this is that other secular organizations that admitted to doing these exact same quote unquote discriminatory hiring practices, right? If they say we'll hire based on some other of these characteristics, they didn't lose any funding. The only group that was really targeted in the actual downfall of this policy was this Christian nonprofit. So 71.5 sued and claiming a First Amendment violation, asking the court to be able to say that they shouldn't have been revoked of this funding. So in the most recent ruling, they had a panel of the circuit court judges ruled that 71.5 can hire co-religionists, but only for programs that don't receive state grants. So as long as they're continuing to hire people only of the same faith and bringing that into account when they make these decisions, they're still ineligible for this funding. And right now they're appealing to rehear the case en banc. So on the legal side of things, on one half, it's a pretty common fact pattern we've seen before with the Trinity Lutheran and Carson v. Macon line of cases, where the basic issue is that a generally available public benefit, in this instance, the grant, is conditioned on the abandonment of core religious values, right? Because 71.5 exercises their faith and hires people that only do the same thing. They have to abandon that religious practice in order to receive this otherwise generally available public benefit, the grants. So that we've kind of seen before. It's gone up to the Supreme Court. It's been kind of all over the place in lower courts. And there's a second, somewhat more novel issue that, again, will center around the church autonomy doctrine. So the most recent panel ruling said that the church autonomy doctrine, or a religious autonomy doctrine, can only be invoked as an affirmative defense and not as a standalone right. So basically, they're saying that a religious organization can't say, oh, this violates the church autonomy doctrine and bring a lawsuit because of that. They can only say, like, the court can't intervene on behalf of a plaintiff in this particular manner because of the church autonomy doctrine. So really, in effect, this really weakens when a religious organization can say you're not allowed to kind of rule in this particular manner because doing so requires intervening in our internal affairs. And that limitation on the church autonomy doctrine very much contradicts pretty established Supreme Court precedent. The appeal noted a few different cases between Our Lady of Guadalupe, which was over a dispute over some Catholic school employees were fired, and in effect it expanded the ministerial exemption under the church autonomy doctrine. They also cited Hosanna Tabor, which was a pretty similar case with the Lutheran school, and the recent Catholic Charities decision that you've mentioned a few times. Between these and other rulings, it's pretty clear that the church autonomy doctrine bars any government intervention into a religious organization's independence in matters of faith and governance and faith and doctrine. So this will be a little bit different than most of the other claims we've seen, where it is generally public benefit is conditioned upon basically your First Amendment rights. There's one half of it. The new thing, like I mentioned here, is kind of the way in which the church autonomy doctrine can be invoked. And hopefully the circuit court agrees to rehear this, because this could impact a lot of religious organizations and basically really limit the times in which they're able to invoke this defense. So Frank, I'll hand it off to you to continue this.
Yeah, just two quick thoughts. One is on the church autonomy doctrine. I think this is one of those subjects, as is the next case we're going to discuss, where I think it would be useful for us to circle back to this with with a guest speaker who's an expert in these particular areas, because I'm not a church autonomy expert, though I know a bit. I think this is still kind of open ground here, where you see fights like in the Ninth Circuit Huntsman case, right? You have some judges who don't apply it at all, and they let a fraud claim against a church go on the merits. And then you have a concurrence that's saying, well, we shouldn't have decided this because they raised church autonomy. And then you have Judge, is it Bumate, who writes a separate concurrence and says, the church autonomy doctrine is not an affirmative defense. It's a jurisdictional threshold. If this is a matter of internal church doctrine, then we can't look at it. We don't get to the facts first and then see if the defense holds up. We don't have jurisdiction to decide these at all. And then this adds another layer to it because, like you said, this is just like the last case. It's kind of tricky how you would apply church autonomy because the idea is there that you're policing doctrine, but it's hard to tell when it quite fits into church autonomy because here it's involving like a public funding that's being taken away. It's hard. It's not like a straight ministerial exception kind of case where you're actually litigating the right to hire or fire according to beliefs. That's not what's at issue. The Oregon says, yeah, you can do that if you want to. Like, we're not saying you don't have the right to be autonomous in your internal hiring decisions. We're just saying we're not giving you money if you do that. So it's wrong, but it changes the analysis. So this is another interesting open question of how this area of First Amendment law actually applies. And then the other nice little bit of color to this case, I think, is states are all over the place with this. But I do think it's interesting that Oregon has removed federal funding here, state funding here, particularly because the ministry only hires co-religionists when Oregon's employment non-discrimination law explicitly allows religious organizations to only hire co-religionists. I just think that's a little bit rich. We had a similar issue in Colorado in a case a few months back, but they particularly say, it is declared to be the public policy of Oregon that practices of unlawful discrimination because of in all these categories, including religion, are prohibited. But then there are all these, it is not an unlawful practice for a bona fide religious institution to take any action with respect to hiring, including hiring on the basis of sexual orientation, preferring people of one religious sect or persuasion over another. I don't want to go on and on here, but it's kind of interesting that they're punishing an organization for taking employment actions that are completely allowed, explicitly allowed by Oregon law. I guess I will leave that one there, and we will finish up with our final topic for the day. So this is really interesting. I'm going to caveat this with, this is an incredibly dense and complicated situation involving medical privacy regulations from Health and Human Services. I'm not an admin law guy. I had to read through this several times even to just get the general gist of the conflict. I know, Joseph, you did too. And so I'm going to just give a brief overview of what happened as best as I understand it, and then just a couple of quick takeaways and encourage people who are admin or regulatory or medical law nerds to reach out to us, because there's another one where I'd love to have a guest speaker and dive a little more deeply into this than I'm able to go. So with that long preface in mind, what happened here is in early 2024, so this was like the tail end of the Biden administration, Department of Health and Human Services amended a medical privacy rule that it had HIPAA implications and some other laws that were in play. So the amended rule effectively prevented or purported to prevent doctors from disclosing certain information related to reproductive health care, so it's abortion in particular, to law enforcement during investigations, including child abuse investigations, right? So there's a lot to figure out here, but the plaintiff who sued here was a doctor from Texas who often treats young women and children and is implicated in these rules. She filed a lawsuit against enforcement of the rule. She argued that this rule, which prevents medical professionals from disclosing information about a patient's history of abortion, in a lot of practical cases, made it basically impossible for her to cooperate with authorities during child abuse investigations. So earlier this year, the district court in Texas decided that the rule was actually contrary to the law for several reasons. And this is where it gets murky. But the one that I did want to briefly highlight is that you have HIPAA, right, which is what everybody refers to when they're talking about medical privacy through federal law. So HIPAA has a provision that's pretty clear that prevents HIPAA from being interpreted or construed to interfere with state laws regarding reporting of child abuse and investigations of this nature. So the district court ruled that the HHS rule actually violates this provision of HIPAA by trying to make federal privacy laws usurp state investigatory powers when HIPAA explicitly does not intend for those federal laws to interfere with those investigatory powers of the state. So there were several other legal issues going on there, but the HIPAA one is what stood out to me. So supporters of the amended rule that was kind of super protecting abortion information, they appealed to the Fifth Circuit. The case was recently voluntarily dismissed. I'm going to get to that in a minute. So as such, the district court ruling that vacated the rule now was upheld, right? So the appeal of the trial court was dismissed and the rule was essentially struck down, and that's kind of the final state of things. ADF, the Alliance Defending Freedom, was defending the doctor here, or prosecuting the case rather, and gave a statement saying doctors and states should be able to protect patients from abuse. As a result of this dismissal, state laws that protect mothers and unborn children from the harms of abortion are now more effective. So again, extremely complicated procedural case. If you read the literature from Alliance Defending Freedom, there's some helpful starting points there. And if you're really into this kind of stuff, you can dive into the trial court ruling and into the rule itself. But a couple quick observations. One, like I said, HIPAA was designed to protect patient privacy without hindering state investigations, especially into situations like child abuse. So when privacy laws like this are extended to prevent doctors from discussing certain things, even during very discreet investigations, right? Child abuse investigations are not like a public trial. There's usually a lot of confidentiality surrounding them, right? Like what doctors say to investigators and what investigators say in court regarding child abuse, most of that remains confidential. This is not public record in the same way that like a criminal trial court case is. So it's a touchy line here between privacy and these kinds of investigations, but HIPAA is clear that its privacy provisions are not meant to prevent doctors from cooperating with these kinds of investigations. And because HIPAA is clear on this, and remember, HIPAA is a statute, HHS doesn't have the authority to interpret a statute or make rules based on a statute that conflict with the statute or are not authorized by the statute. So if you're a lawyer and you're into these kind of admin issues, right, the major questions doctrine is implicated here, that when a rulemaking agency is making a rule that touches on a major question of policy, they can't do it unless it's pretty explicitly authorized by the statute. And this was basically trying to super protect abortion, which is one of my other points. And that's not authorized by the statute, especially when it's conflicting with state investigatory powers. But I think one of the things that's interesting here is if at first it looks like, okay, more protection for medical privacy from doctors disclosing private medical information to government bodies sounds good. But the thing is, we already have this balance in our policy, and there, like I said, there's something of like a super protection that the HHS under President Biden was trying to do here. It's like, okay, we acknowledge that medical privacy matters, but not to the extent that your like doctor is going to keep it away from a child abuse investigation, right? Because that's really important. There's a state interest there. Oh, except if the medical procedure in question involves an abortion, then even then your medical privacy somehow all of a sudden trumps a child abuse investigation, even though it doesn't do so in any other instance. So there's definitely some politics behind the rule. One final thing I'll say is a procedural note that I think is confusing. You're like wondering why there was a voluntary dismissal of the Fifth Circuit appeal. I just wanted to clear that up quickly. So here's the posture of the case. So the doctors, right, a series of people sued HHS. So the doctors represented by ADF are the plaintiff. HHS, then run by the Biden administration, is the defendant. And then a third party, which was two cities and also a group called Doctors for America, who are not involved in the original lawsuit. They intervened. They made a motion to intervene as a third party to participate in the lawsuit. Okay. So they were on the side of the rule and of the Biden HHS. So when the district court struck the rule down, right, the third party was the one to appeal. And then, but the original defendant who had been sued was HHS, which is now run by a new administration, right? The President Trump's administration is now in power. So they have no interest in proceeding with this appeal, which means the third party, two cities and some group, has now lost the support and likely all the resources of the federal government in fighting this appeal in the Fifth Circuit. So the third party withdrew its appeal, and they cited that they thought that it wouldn't be worth the resources of the government or of the court, I forget exactly what, to continue with this appeal. So I think basically that's what happened is HHS was the big guy, and then there was kind of a little guy who intervened, and then all of a sudden the little guy was the only one left who wanted to continue the appeal. And so for one reason or another, they thought they would lose, or they didn't have the resources they wanted to spend on this. They withdrew the appeal. So I know fairly complicated posture, but it was worth kind of, for me, figuring out, wait, why was this voluntarily dismissed? That seems to be why. So very complicated case, as I've said several times, but an interesting one. And in the end, with the result that the super protection for abortion privacy was actually struck down by the district court, and that ruling is now final. So Joseph, anything you want to add before we wrap up here?
Yeah, like you had mentioned, some of the legal questions in this one get a bit murky and a bit complex. I know when I first started reading the case, it took a couple passes through to really understand what was going on the legal side. But what's helpful for me, at least in this case, was looking at, well, who's the plaintiff and what are they saying they're not able to do anymore? And the fact of the case is, this doctor says, I'm not able to protect my patients anymore because of this rule, and I'm not able to cooperate with these child abuse investigations. And that helps starts to kind of bring some color into what the question here going on is. It's quickly becomes a medical conscience rights issue when a doctor is saying, I'm not able to actually do my job how I know I'm supposed to because of this regulation. And I think that really just kind of helps clarify some of the questions of what's the issue and why is this such a big deal? Except for this instance, it looks like, okay, they're trying to, provide some more protections for patients. Like it looks like it has at least well-intentioned. But when you start looking at, well, what are the suits that come out of it? It's pretty clear that there's some pretty problematic implications and some motivations behind it. When the rule was first amended, it was done explicitly because of the Dobbs decision, and this was an attempt to protect the procurement of abortions. And ultimately, that makes it clear that this isn't a matter of privacy; it's a matter of ideology, right? It's making it so doctors can't protect their patients how they know they're supposed to. So we'll see how this continues, or actually it's finished playing out because it was voluntarily dismissed. So it's good to see kind of this reach the resolution that protects doctors and ultimately protects patients.
Great. Well, that was a lot, a kind of a dense week. But with that, I think we will wrap up. So thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate if you like the podcast, subscribe to our channel on YouTube, Spotify, or wherever you're listening from. Also, if you want to support the work we are doing, we always appreciate it. You can donate to the organization at napalegalinstitute.org. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. So we'll talk to you next week. Thank you for joining us. God bless you.